All right, hi everyone, welcome to our course. I'm Professor Lord, and as you saw, for this course, we generally focus on public law. You might have seen from the general course description that I kind of moved away from what prior professors have done, and this is a course that really focuses on public law, specifically generally on Section 15 of the Canadian Charter of Rights and Freedoms, which guarantees the right to equality. And most of our focus is going to be on Section 15 for about 2/3 of the course. And I think it's the most relevant protection of equality in Canada. As we'll see, there's various protections in provinces and human rights codes. But Section 15 is really given some thrust to these provisions and to a large extent has caused their creation in various provinces. So first, from the reading from this week, there's nothing there's nothing important that we're not going to look at again over the course, but still helpful to have kind of an overview of Section 15. I think the reading is that pretty well. One thing to know about Section 15 to start with is that it's really not used that much. Generally, courts have seen it as kind of a nuclear bomb where it has a lot of potential, right? The protections are very broad, and it's very easy to claim unequal treatment or discrimination when other rights are engaged. So the result of that is when someone is claiming that their rights have been infringed under the Charter, right? Generally, they'll go to court prior to getting the Supreme Court, they'll go to Superior Court, then on appeal, then they'll ask for permission and eventually get to the Supreme Court. Well, if they want the whole thing to work, generally they'll claim that more than one of their rights was infringed. And for the reason I just mentioned, generally courts are going to find that it's better to rule under these other rights. If someone says the right to life has been infringed, generally courts will find an infringement under Section 7 of the Charter as opposed to Section 15 because it's drafted very broadly, and courts can be afraid of the precedential value of that, right? Can be afraid that Section 15 is going to trump other rights in the Charter and is going to be successfully invoked every time. You have Section 15, it's reproduced in full on the first page of your reading, and it's relevant to look at it here in great detail. You'll see from this course that every single word in there is extremely relevant. So first you have two subsections there that do two different things, as we'll see. 15.1 says you can't discriminate, basically. Section 15.2 says, well, sometimes you can discriminate if you have a good reason. We'll see what a good reason means. Generally, it means addressing existing disadvantage. So the legislator was likely worried of some problems in the United States with what we call substantive equality, right? Basically giving rights to certain groups of people who've traditionally been disadvantaged. And courts have found that that can be a violation of equality because essentially you're not treating everyone the same, which is a conception of equality which we call formal equality, as opposed to substantive equality, which looks at more context, which looks at historical disadvantage and the situation of people before you give them these rights. And so the legislator was careful there to include that in Section 15.2 and to say if you're trying to have what's called an ameliorative purpose, if you're trying to correct existing inequality or disadvantage, you're okay. Even though, as we'll see, you are in fact perhaps infringing upon the equality provision, which is Section 15.1. I'll read it out loud because it's worth it. Section 15.1 says, every individual, we'll see what individual means, is equal before and under the law and has a right to equal protection and equal benefit of the law without discrimination, right? So equality generally means discrimination. You don't treat people the same, and you do that in a way that's illegitimate. And, in particular, without discrimination based on. And then you have a list of things. What does that mean, right? And in particular. So the list that comes after that is not what we call exhaustive. They're examples. It's not the only thing that you can discriminate upon. What's the list? Again, not exhaustive, so you can go to court and claim something else. Race, national or ethnic origin, color, religion, sex, age, or mental or physical disability. That is what the legislator wrote down in 1982 when they came up with the charter. But of course, the way it's phrased, courts have the ability to, and did avail themselves of that ability after 1982 to add to that list. Section 15.2 says, again, this is the ameliorative purpose there, right? When you can discriminate because you're trying to do something good, Section 52 says, subsection 1 does not preclude any law, program, or activity that has as its object the amelioration of conditions of disadvantaged individuals or groups, including, again, this is not exhaustive, those that are disadvantaged because of, and then you have the same list as in subsection 15.1. As I mentioned, as we move down, you have the statement that oftentimes these rights are protected in greater detail under provincial or human rights codes. So provincial laws or human rights code. Why is that, you ask? Well, it's because we have to be mindful here that it's section 15 of the Charter, which is part of the Constitution. So the Canadian Charter of Rights and Freedoms says you have these rights which we think are very important, and so we'll give them more value than any other law. So if someone tries to come up with a law that violates one of these enumerated rights, the law is likely going to be invalid, making things simple here. And section 15 is part of that, and so a law that violates this guarantee of equality and to be protected from discrimination, if it violates that, it is most likely going to be invalid. But the Charter only applies to essentially the government. So it only applies to public bodies. So there is no such thing as you going into a convenience store and then someone treating you poorly and then you going to court and suing the convenience store clerk saying they discriminated against you. The Charter just doesn't work that way. In the same way, you can't claim that your other rights under the Charter have been infringed upon by private individuals. You can't go to court and say someone infringed upon my right to liberty, right? Might be a crime, might go to jail for it, but of course, it doesn't mean that you can claim that they violated the Charter and try to get damages specifically under the Charter. Therefore, that is where provincial laws or human rights codes come in. Generally, they have a broader ambit of protection. They don't just apply to public action, which is not really that narrow to start with, of course, because it covers laws, right? It ensures that laws don't violate Section 15, your equality rights. But generally, human rights codes and provincial laws are going to go further and cover your relationship to companies or relationships between two private individuals. Anything not having to do with a private individual and the government. You have that at page 2 of the reading. Basically says the same thing in greater detail. You also have, a bit later on, the fact that corporations do not have Section 15 rights, because Section 15 says, right, persons, generally that's what the Charter says, even though it doesn't necessarily say it explicitly in Section 15. A moral person, right, a corporation's a moral person, under the law, has many of the same attributes as a person, but you're told corporations don't have Section 15 rights. Then you have this idea that I already discussed a bit of substantive equality. So what does equality mean, right? Because Section 15 says you have a right to be treated essentially equally and without discrimination. Well, what does equality mean? A substantive conception. So again, not just treating everybody the same, but ensuring that people are treated the same effectively when taking into account various circumstances, including historical disadvantage that some groups might have faced. What's the test for that? Well, it's in a case called law, which we'll read, I think, for the next session or next week. And you have a framework there that's basically not particularly complicated, right? First step is there a distinction, right? Distinction between different people, different groups of people. And second, is it discriminatory? So is it based upon the things we said, right? Race, color, and so forth, right? Race, disability, right? The list that we saw in subsections 15.1 and 2 is the distinction based upon that. Then, of course, you still have section 15.2 as a kind of catch-all there, right? So even though you do have a distinction, right, after you've shown that there's a distinction, and even that it might be discriminatory, right, it's your burden, as we'll see, as the person going to court, the person saying you've infringed upon my rights, right? You have to show that. It's not true by default. Well, then, after you've shown that, the government can still use section 15.2 and say, yeah, it's discriminatory, but we got a good reason, namely that we're trying to do something good, having to do with making people more equal. And then the burden is on the government. So if the government wants to invoke section 15.2, say, we'll call it a defense, not exactly true, but as a defense to, as a reason for that infringement, it is for the government to meet its burden of proof and show that. Then you have a statement that the analysis is contextual and comparative. Essentially, right, we consider the specific facts of each case, and each case is going to turn on its own facts. It's significant because initially, right, in say early cases around the 90s, we had a requirement to compare. Right? So we had a requirement to come up with this imaginary or somewhat artificial group of people who were in the same position as the person claiming discrimination, except for the specific characteristic based upon which, they were alleging discrimination. And that led to all sorts of problems.
Could you try again?
No, it's not exactly true, right? That changed after CAP and with various other cases that kind of redefine that, which we'll read either Wednesday or next week. And that removed that focus on the comparator group. And even though section 15 remains what they call inherently comparative, right, in the sense that discrimination or inequality means you're being treated differently than someone else, right? The someone else, we don't focus on that much, right? We don't draw artificial boundaries and try to be very specific as to who that someone else is and why it is that you are different from them. Then you have a statement at page 4, right, that the burden, as I said, lies upon the claimant. As I said, if you're alleging discrimination, you have to prove that. And what is your burden of proof? Well, generally, you're going to have to consider, right, various facts, as I said, and generally that's going to mean adducing evidence. So basically, right, the reading tells you if you're not saying something, and that's just me kind of rephrasing it a bit here, but if you're not saying something that is obvious, you'll have to prove it. So if you're saying, right, that say deaf people have a harder time hearing things, that's going to be considered obvious. You're not going to have to come up with scientific studies that say deaf people can't hear. However, if you're saying something more nuanced, or if you're saying something like, well, deaf people have a harder time accessing the job market, and therefore they tend to be poorer than most people, right? It's going to be kind of an indirect, right, statement. Well, in that case, you'll generally have to adduce what we call social evidence. You'll have to adduce evidence that's actually true, and generally it's going to mean evidence that links these two characteristics of the groups you're claiming together, right? There is a relationship between being deaf and being economically disadvantaged. So back to this framework that I discussed, right, under section 15.1, right? As I said, two things. You have to show a distinction. That's all going to be expanded upon in the readings, of course, right, for the next couple sessions. So first, a distinction. Second, has to be discriminatory based upon the list of things that we saw in subsections 15.1 and 2, or some other analogous grounds, something similar that wasn't mentioned because, as we said, the list isn't exhaustive. And that means also, right, that you don't have to directly have an impact upon the person, right? So of course, if you have a law that says, right, you will get social assistance unless you're a Jew, that's a law that is on its face discriminatory, right? So the text of it says we treat Jews differently, right? You don't have to dig around, it's written in there. That's what we mean by on its face. It's going to be a law that is in itself discriminatory. Of course, oftentimes, right, governments aren't that dumb, right? Governments aren't going to write such a law because they know that it'll get struck down. And oftentimes also, because of the ways in which, right, our identities are created, because of the ways in which various things kind of combine to create who we are, right? How various things also interrelate, how race interrelate with gender and social status to create someone's identity, but also to create the barriers that people face in their lives. Well, as a result of that, oftentimes a law will be discriminatory, not on its face, but based on its effect. So the law, in effect, is going to treat people differently, right? The example you have is, right, if people have to take Saturdays and Sundays off, well, if your religious holiday is not on a Saturday or Sunday, well, of course, it's going to impact you in a different way. It's going to impact your ability to practice your religion in a way that is not true for people who have their religious holidays on a Saturday or a Sunday. So that's to apply the framework I just mentioned. First, a distinction, right? And again, these are all things that we'll look at in greater detail. But first, a distinction, simplifying things, that is discriminatory. And discriminatory means, you'll see my handwriting doesn't get much better over the semester. A distinction that is discriminatory, which means basically based upon either the list of things that we saw or something similar. You see on page 6 of the readings some grounds that were held by the Supreme Court to be analogous. Why is that relevant? Because once the court says it once, you don't have to prove it again. So if the court says, right, someone comes to court and says, I've been discriminated upon based on my marital status, right? How does that apply? Well, say there's various laws that say you get a pension if your husband dies, but only if you are married. It's very common, right? Well, if you are not married, there's a distinction upon marital status that has an impact on you, namely that you don't get the money. The court says, in a case, right, marital status is an analogous ground. So not one of the things that are listed in 15.1 and 15.2, but similar enough, and so it counts. It is one of the things that you can discriminate upon. Once a court says that, you're good. You don't have to prove it again. So in subsequent cases, right, you don't have to again say that marital status is an analogous ground. Once the case law says it is, it is. It's really as if it had been written down in the list in 1982 by whoever wrote down the list. Of course, you'll still have to show that there is indeed discrimination on the facts based on marital status, right? But you don't have that preliminary step. You also have things there that are not, right, analogous grounds. Generally things having to do with what the court considers overly indirect links. So poverty, the court says this is highly debatable, but the court says, right, not as much of an immutable characteristic, something that you can't really change, or that you can't change without it not making sense, without the effort making no sense. court says this is not the kind of thing, poverty is not the kind of thing that is an immutable characteristic. Same for professional occupation. Prisoner status as well is not an analogous ground. Kind of surprising when you think of the criteria I've just mentioned. Then you have a list of factors that we'll see in greater detail in a case called Law, right? So the lady in that case, her last name was Law, and so that's what the case is. And essentially, right, page 8 of the reading, you're told these things don't really matter, and they're particularly confusing, and so the reason I'm mentioning them here is to tell you to basically ignore them. So the court set out, and again we're under section 15.1. So in determining whether there is discrimination in the first place, before section 15.2, the government comes in and says, well, we got a good reason, right? So before that, whether or not there's discrimination, the court says there's 4 factors, 4 contextual factors, and they're still useful as we call interpretive aids. So stuff that you can look at to try to see whether there is a violation. So there's still things that you can look at, generally commonsensical things that you can look at, but they're not things that you have to look at, or things that where you don't meet one of the 4 things, then it's not discrimination. It's just indicative, not mandatory. And what are these, right? Pre-existing disadvantage of the person or the group, kind of makes sense, right? Degree of correspondence between the treatment and the group. Basically, right, discriminatory distinction. C, whether it has an ameliorative purpose. And that's where it gets confusing, because that's basically section 15.2, which the court seems to have gotten wrong, and which is now a distinct aspect of the analysis. As I said, basically a defense or rebuttal, government can come in and say, well, we got a good reason. So it is no longer accurate to say that it's a factor under the preliminary, right, the discrimination part, which is section 15.1. In the nature of the interest affected, right, whether whatever you're taking away is important. So in my pension example, right, taking away someone's right to get money for their entire lives until they die, well, the interest affected is significant because the person is losing something very important to them, namely money until they die. And you have these factors, right, which are expounded in greater detail. There's nothing important there particularly, even though it does give you a sense of what discrimination means, right? So discrimination is the sense of not treating people with, in a fair and equal way, in a way that preserves their human dignity, right? Their ability to be treated like people, right? Not like animals, not like trees, not like lambs, like people, right? Having a respect for that aspect of human life. We're also told that stereotypical distinctions are often discrimination, which makes sense, right? So taking characteristics and blowing them out of proportion, or making a distinction based on a historical aspect or characteristic, is generally going to amount to discrimination. Then you're told at page 10, essentially what I just said, the part where they get the sections wrong is no longer the law in Canada. Finally, the framework under section 15.2, so that ameliorative purpose I've just mentioned, that defense, right? The government's saying it is discrimination, but we got a good reason. We're trying to do something good, and something good having to do with section 15, something good having to do with, right, creating more equality and less discrimination, and therefore you should allow it. The typical example of that is, as I said, right, if a group has historically been disadvantaged, the government provides them specific benefits to try to account for that historical disadvantage. And as we said earlier, right, they work together to promote substantive equality, right? So we said substantive equality underlies section 1. So in determining under section 15.1, right, subsection 1, sorry, whether there is discrimination, we consider substantive equality. We don't consider whether people are treated the same we consider whether in effect they are being treated the same. Well, section 15.2 is also underlined by that purpose because it says, right, if the government is trying to provide specific benefits to further equality and reduce discrimination, right, we allow that under section 15.2, and that amounts to furthering that same vision of substantive inequality. Again, we have a two-step test under section 15.2, which we'll again look at in greater detail, right? Basically, right, the program has to do something having to do with section 15.2, so ameliorate, and second, right, it has to target the group of people. So this is important because, right, first, it has to have an ameliorative purpose. And we'll see it's significant because it means the government doesn't have to actually do it. And generally, of course, when you pass a law, right, you don't know for sure if it's going to work yet. And so the government has to go to court the next day and try to prove that the law is consistent with the charter. Well, the government might have trouble doing that because even though the law will work, there's not yet any proof that it does. So what we look at is the law's purpose. So the government can't just say, we're trying to do something good. That's not enough, right? But once there's a good sense that there is indeed a reason to believe that the government's trying to do something good, right? They didn't just say it. It makes sense. Then we don't look at whether the law actually works, right? Actually achieves that purpose, the significance. So an ameliorative purpose. Second, right, the program targets the groups. Again, the groups we mentioned based on enumerated or analogous grounds. Enumerated being the ones we saw in sections 15.1 and 2, right, race, mental ability, and so forth. And analogous grounds being, right, the ones that are added by courts subsequently because, as we said, the lists are not exhaustive. Significant though, I'll underscore it again, under the second part there, right, you can't target, say, white Caucasian people. You have to target people in the list or in something kind of like the list. And so section 15.2 doesn't serve to pass laws that help some people. They serve to pass laws that help some people who have been historically disadvantaged, generally based on the list of things that we saw in the text of section 15.2. So that kind of narrows the scope of what you can do with section 15.2. Even though you might be trying to do something very good and that furthers equality for Caucasian people, it's not enough because there's no historical disadvantage. So section 15.2 is not going to save you there. Then there's a distinction that's drawn in the reading with section 1 of the charter, which is something that really comes up in all of our courses, but that we never really look at in great detail. Section 1 says you can infringe basically any right, that's not actually true, but for our purposes it is, under the charter for some reason, right? Because, of course, governments are going to infringe upon people's right quite often, right? If you put someone in jail, then you're really taking away all their rights, right? Their right to life, liberty, security of the person, right? Lots of rights, but still we're allowed to put people in jail because we think we have good reason for that. It's under section 1. So section 1 says, right, has an external limitation. Some rights have an internal limitation. Section 7 is an example. So section 7 is going to say, right, you have a right to life, liberty, as I said, except for, right, what we call principles of fundamental justice. Second, right, you have an external limitation under section 1. So all the rights, right, except for some, that don't have an internal limitation, and those that do, right, have a further limitation, you can infringe upon under section 1. Section 1 allows a government to infringe upon all these rights. There's tests, right, that we under a precedent called Oakes, right, that essentially looks at, right, whether the government's trying to do something good, right? So generally the government has a purpose. There has to be what we call a rational connection between the purpose and the intent, right, what the government's trying to do. And on top of that, right, it has to be proportional. So the government can't, right, try to, say, prevent 2 crimes by putting everyone in jail for 10 years minimum. It's not proportional, even though, of course, it might be rational. The connection might be rational, right? Might be a way to prevent the 2 crimes. It's not a proportional way to prevent the 2 crimes. It's the test under the precedent of Oakes, which we call the Oakes test. What's important here is that the same word is being used under section 15.2, right? So section 15.2 under the ameliorative purpose is going to look at whether there's a rational connection between what the government's trying to do. So as I said, right, it's not enough for the government to say we're trying to solve inequality. It has to make sense. It doesn't have to be proven, right, that it does, but it has to make sense. And we look at whether there's a rational connection, basically whether the law seems to be a rational, a sensical way to do that, to combat inequality and discrimination. So in some way, right, for our purposes, as is emphasized in the reading, is a limitation of some kind, right? So not any law that has a rational connection, and confusingly, we won't look at that in great detail, so I'll go to mention it because it is the same word. Section 1 also requires basically the same thing. Section 1, again, to limit the rights. So including Section 15, there's a discriminatory law that violates Section 15. Well, then you can go under Section 1 and say, well, we got a good reason, right? Well, one of the things required for it to be a good reason is a rational connection between what I call the intent and the purpose. So the intent and what the law is effectively trying to do. So what the law does and what the law tries to do, there has to be a rational connection, and the same is true under the framework for Section 15.2.